Hi, my name is Davila Devirolal as the first presenter.
Hi, my name is Jessica Lumit. I'm the second presenter.
Hi, my name is Nurul Izayudinanda and I am the third presenter.
Hi, my name is Farida Sindambul and I'm the fourth presenter.
Hello, my name is Stephanie Angeline Anasuring. I am the last presenter.
The curator is an independent professional and qualified person who manages and investigates the affairs of the company during the process of winding up. Section 2 states that liquidator includes of official receiver acting as the liquidator of corporation. Regarding to the case from the questions, the reason the company decided to cease their operations as the period fixed the constitutions for the duration of the company expires and on the appearance of which the constitution provides that the company is to be dissolved and the company in general meeting has passed a resolution requiring the company to be wound up voluntarily as stated in section 439 subsection 1 and subsection A. There are two ways in which a company may be wound up: by the company voluntary winding up, or by the court compulsory winding up. But regarding to the questions, the method for winding up of a company is voluntary winding up. Voluntary winding up is divided into two categories, namely members voluntary winding up and creditors voluntary winding up. Section 433, Subsection 2, Subsection A, by a member's voluntary winding up where the company is solvent and the liquidator is appointed by members at the members meeting, or Section 433, Subsection 2, Subsection B, by a creditor's voluntary winding up where the company is insolvent and the liquidator is appointed by the creditors at the creditors meeting. We look up to the case from the question, which mentioning declaration of solvency and was negligently prepared, clearly showing that this is the main problem of the case from the question. As declaration of solvency often precedes the process of members voluntary winding up, when shareholders wish to liquidate a solvent company, this document allows company directors to make statutory declaration that states the company will be able to repay its debt and interest within a fixed period not exceeding 12 months. According to Section 443, Declaration of Solvency, where it is proposed to wind up a company voluntarily, the director, or in the case of a company having more than one director, the majority of the director may make a written declaration to the effect of the directors have made an inquiry into the affairs of the company, and meeting of directors have formed the opinion that the company will be able to pay its debt in full within a period not exceeding 12 months after the commencement of the winding up. Upon the winding up of the company, whether the compulsory or voluntary, a liquidator will be appointed to realize all the assets of the company and subsequently distribute this asset to the creditors of the said company. A liquidator should have a relevant qualification according to Section 433, Qualification of Liquidator. Section 433, Section 1, he is not an approved liquidator. He is indebted to the company or to a corporation that is deemed to be related to the company by via of Section 7 in amount exceeding 25,000 ringgit. He is an officer of the company. He is a partner, employer, or employee of an officer of the company. He is a partner of employee and an employee of the officer of the company. He assigned his estate for the benefits of his creditors or has made an arrangement with his creditor under any law relating to bankruptcy. If he becomes bankrupt or if he is convicted or an offense involving fraud or dishonesty punishable on conviction by imprisonment for 3 months or more. The court held that the director had breached their fiduciary duties and were liable to identify the company for any losses or damages arising from their negligence. The case that related to the case from the question is Rikianjo Holdings Sendirian Berhad 2018, Malaysian Law Journal Unreported, whether the director liable for any losses or damages arising from their negligence. This is a case where the High Court set aside a declaration of solvency made by the directors of a company that was undergoing a member's voluntary winding up. The court found that the declaration was made without due inquiry and was based on erroneous and incomplete information. The court also ordered the company to wound out under the creditors' voluntary winding up mode instead.
For the application of this case, upon the case Rikianju Holding Sendian Berhad, the director prepared the declaration of solvency based on erroneous and incomplete information. In this situation, Sarah has duly negligence prepared the declaration of solvency with serious miscalculation. If the company is actually insolvent, it is no longer a member voluntary winding up, but instead falls under creditors voluntary winding up. According to section 432, subsection 2, subsection B, voluntary winding up may be affected by the resolution either by the creditor where the company is insolvent and the liquidator is appointed by the creditor at the creditor meeting. In conclusion, therefore, based on the situation, the company can be wound out by the members voluntary winding up, but to be wound out by the creditor voluntary winding up instead. For the next situation, the issue is whether the Sarah can apply for winding up by the court. The definition of locus standi is the right of a party to appear and be heard before a court. For the winding up, it means as a process which the existence of a company is brought to an end in which assets of company are collected and realized. The proceeds collected are used to discharge the company debt and liability, and any remaining balance, if any, will be distributed among the contributors according to their entitlement. Under Section 2 of Company Act 2016, the liquidator is included the official receiver when acting as the liquidator of a corporation. Liquidator is a person that is an independent, professional, and qualified person who manage and investigate the affairs during the process of winding up. The liquidator has to realize or liquidate the asset. Under Section 464 of Company Act 2016, petition of winding up under an order of the court on the petition of the following, which are by subsection A are the company, B any creditor including a contingent of prospective creditor or of the company, subsection C a contributory or any person who is the personal representative of a deceased contributory or the trustee in bankruptcy or the Director General of Insolvency of the estate of bankrupt contributory. Subsection D, the liquidator. Subsection E, the minister. Subsection F, the licensed institution. Subsection G, the operator of designated payment system. Subsection H, the register. And lastly is subsection I, the member institution under the Malaysia Deposit Insurance Corporation Act 2011. There are 12 grounds listed as the circumstances for a compulsory winding up. Under Section 465 of Company Act 2016, circumstances in which company may be wound up by the court. Subsection 1, the court may order winding up if, subsection A, the company has a special resolution resolved that the company is to be wound up by the court. Subsection B, the company default in lodging the statutory declaration under subsection 190, subsection 3. Subsection C, the company does not commence business within a year from its incorporation or suspend its business for the whole year. Subsection D, the company has no members. Subsection E, the company is unable to pay its debt. Subsection H. Take out letters of administration of the estate of any deceased contributory or debtor, and do any other act necessary for obtaining payment of any money due from a contributory or debtor. His estate, which cannot be conveniently done in the name of the company, and in all such cases the money due shall, for the purposes of enabling the liquidator to take out the letters of administration or recover the money, be deemed due to the liquidator. Subsection I. Make any payment as necessary in carrying on the affairs of the company in its ordinary course of business, including payment of utility bills, statutory fees, and all other such payment. Subsection J. Appoint an agent to do any business which is the liquidator is unable to. Subsection K. Appoint an advocate to assist him in his duty. Subsection L. Do all such other things as all necessary for winding up the affair of the company and distributing its asset.
Under the 12th schedule, part 1 of section 472, the liquidator may, subsection A, bring or defend any action in the name of or behalf of the company. Subsection B, compromise any debt. Subsection C, sell properties and things in action of the company. Subsection D, do all acts and execute in the name and behalf of the company. Subsection E, prove, rank, and claims the bankruptcy of any contributory. Subsection F, draw, accept, make, and endorse any bills or exchange or promissory note in the name or on behalf of the company. Subsection G, raise on the security of assets of the company any money requisite. Subsection H, take out letters of administration of the estate of any deceased contributory or debtor and do any act necessary for obtaining payment. Subsection I, make any payment as necessary in carrying affairs of the company. Subsection J, appoint an agent to do any business which the liquidator is unable to do. Subsection K, appoint an advocate to assist him in his duties. Subsection L, do all such other things as are necessary. There are one related cases, which is Litar System Adil Kap Sujan Berhad against Lee Tiap Hock and Lee Sun Ho. The issue of this case is whether the petition of winding up are allowed. The company is the respondent and the petitioners are directors and shareholders. The biggest shareholders, T. Tiap Koi, or also known as LTK, as well the director of the company. Both petitioners removed by the company under the few resolution whereby a money lending license belonging to LTK in his sole proprietorship called T.K.Lee Enterprise was to be transferred to the company without any payment. The company take over the money lending business from Enterprise for the consideration of certain amount of money and the amount transferred or be paid to Enterprise. The money never transferred to the company and under dissatisfied amongst others. The petitioners filed a winding up. It was later held that the court allowed the winding up petition to wind up because the company involved in a licensed business without being duly licensed. It is an abuse of the company's financial account by transferring money from the company to Enterprise without any valid reason, and the company's directors had acted in their own personal interest or acted in a manner which is unfair and unjust to its member. In applying Part 1, Section 472, Subsection D of the 12th Schedule of Companies Act 2016, the liquidator may do all acts and execute in the name and on behalf of the company all deeds received and other documents, and for that purposes, the company seal when necessary. In applying Section 464, Subsection D of Companies Act 2016, liquidator, which means an independent and professional and qualified person who manages and investigates the affairs of the company during the process of winding up, is one of the parties who have local standing, which means the right of a party to appear and be heard before a court in the petition of compulsory winding up. In the question given, Sarah is an interim liquidator, thus have the rights to requisites a compulsory winding up. In applying the case of Litar System Adil Kams Sudian Berhad against Lee Tiak Hong and Lee Sun Hong, Tiak Hong and his son were appointed as directors and shareholders of Litar System and money lending business belonging to a director and also the biggest shareholder of Litar System is transferred to Litar System without any payment. The similarities is that Tradex Sedian Berhad funds amounting 750,000 was transferred into the company's managing director's personal account since the past 3 years. Therefore, based on situation as the interim liquidator, Sarah can apply the Tradex Sedian Berhad for winding up by court because the company directors has been discovered to act for their own interests and not for the company.
Based on Section 2, liquidator means an independent professional and qualified person who manages and investigates the affair of the company during the process of winding up. So, I want to tell what is minority, which is related to this case. Minority means brought by a minority shareholder against the company or its director if they can show that their rights as shareholder have been unfairly prejudiced or that the affair of the company have been conducted in a manner oppressive to them. In other name, minority are shareholders or directors have less control and influence compared to majority. According to Section 465, Subsection 1, circumstances in which company may be wound up by court. Subsection 8, the company has by special resolution resolved that the company is to be wound up by the court. Subsection B, the directors have acted in the affair of the company in the directors' own interest rather than in the interest of the members as a whole or acted in any manner which appears to be unfair or unjust to members. Subsection H, the court is of the opinion that it is just and equitable that the company be wound up. They have case that relate to this section, which is Ibrahim against West Brown Limited and ours. Whether it's just and equitable to wind up the company. The company consists of two shareholders, which is Nazar and Ibrahim, where both of them are the shareholders and directors of the company. They will not pay any dividend but receive wages. Later, Nazar's son joined the company as a shareholders and directors, and now father and son control the company. They terminate Ibrahim, which caused him loss of income. Ibrahim made a petition to wind up the company. It was held that when Ibrahim and Nazar set up the company, it is on the basis that the nature of their relationship or equal partners in the business would remain the same. Despite the fact what the Nazar did was perfectly legal, it was just and equitable that the company be wound up. Upon the issue, Amar and Reza were the two initial shareholders and directors as well, and subsequently Reza's wife, Liana, joined the company as shareholder and also assumed the role of director, causing Amar became a minority and also major disagreement arose between both parties. An ordinary resolution was then passed for the removal of Amar. Although this action were legally permissible under the company's articles of association and general company law. Amar agreed that the removal was done in a perceived manner and was unfairly prejudicial to his interests as minority shareholders. Based on the personal relationship between the parties, it would be inequitable to allow Reza and his wife to use their right against Amar so as to force him out of the company. In conclusion, therefore, based on situation, it was just and equitable to one out because Amar may receive his capital interest.
Next is regarding Azlan's situation. The issue is whether Azlan has discharged his right duties. I will apply Section 2 of Companies Act 216. Liquidator includes the official receiver when acting as the liquidator of a corporation. Liquidator is defined as an independent, professional, and qualified person who manage and investigate the affairs of the company during the process of winding up. Next is our using Section 452, distribution of property of a company, subject to the provision is relating to the preferential payment under this Act. The property of a company shall, on its winding up, be applied equally in satisfaction of its liability, and shall, subject to that application, be distributed among the members according to the rights and interests in the company, unless this Constitution otherwise provide. The liquidator may distribute the asset on company on following the ranking of funds. The next section that I will be applying in Azlan's situation is under Section 486, Powers of Liquidator in Winding Up by Court. Subsection 1, where a company is being wound up by the court, the liquidator may, subsection A, without the authority under paragraph subsection B, exercise any of the general powers specified in Part 1 of the 12th Schedule, and subsection B, with the authority of the court or the committee of inspection, exercise any of the powers specified in Part 2 of the 12th Schedule. Subsection 2. The exercise by the liquidator in a winding up by the court of the powers conferred by this section is subject to the control of the court, and any creditor of contributory may apply to the court with respect to any exercise or proposed exercise of any those power. And next is under Section 486, Settlement of List of Contributories and Application of Asset. Subsection 1. As soon as practicable after the making of a winding order by the court, the liquidator shall up subsection A cause the company's property to be collected and applied to discharging and the company's liabilities, and subsection B consider whether subsection 2 requires the settlement of a list of contributories. Next, under Section 466, definition of inability to pay debts. For subsection 1, a company shall be deemed to be unable to pay in debts if, subsection A, the company is indebted in a sum exceeding the amount as may be prescribed by the minister and a creditor by assignment, or otherwise has served a notice of demand by himself or his agent requiring the company to pay the sum due by leaving the notice at the registered office of the company, and the company has for 21 days after the service of the demand neglected to pay the sum or to secure or compound for it to satisfaction of the creditor. This is referred to the company was insolvent. So insolvent is defined having ceased paying or unable to pay debts in full within the next 12 months. So based on section that regarding on Azlan's situation, the liquidator should follow up on the ranking of funds to be distributed. First, is he or she must pay first the federal taxes. Next is distribute the fund to company's contract, then to the company business. Then liquidator must settle the legal dispute. Settle any legal dispute, the liquidator may have to take legal advice to do that after the company's winding up order. Then sales of asset. The liquidator sells any asset by public tender, public auction or public trading. Next is distribute any funds to creditor and retaining share capital to the shareholder. The second last step is for liquidator is the creditor's claim. Whether the creditors will receive their claims in full will depend on the value of the asset realized by the liquidator. Last but not least, the distribution will be on the basis of pari passu. The application for the situation is in applying section, Azlan must distribute the asset of company, following the rank of funds. The liquidator's primary role in winding up proceeding is to ensure the fair distribution of company's asset to the creditors and contributors. In discharging his role, a liquidator stands in a fiduciary position to protect the best interests of the creditors and contributors. He is required to perform his duty with high standard of care and diligence attributable to a professional person. Conclusion to this situation is therefore, based on the situation, Azlan had no discharge his right of duty because he did not follow up on the ranking of funds to be distributed. That's all from us. Thank you.